I'll tell you one good experience. It actually came out of a frustrating experience. We were in trial. My partner and I were in a trial on a contempt proceeding against the bad guy. That he was not complying with the court's preliminary injunction to let our client back into the business that he had frozen him out of. And so we were in there on a contempt proceeding that had gone a couple of weeks, and this was a Muslim-owned business. And the judge kept making these comments that, well, the contemnor was the elder in the family, and so we have to defer to these cultural differences. And we said, "The hell you do! This is a court of law." So finally, we decided, what are we going to do if the judge has the thumb on the scale based on these cultural differences that shouldn't have any application in a court of law? We consulted with a retired judge that we know, and on his advice, we asked for an in-camera proceeding to discuss this, and to make a record of it, we brought in our own private court reporter because we were calling into question, judicial propriety, judicial bias. So we had to have our own court reporter there. So there we are, crammed into the court's chambers, the judge's chambers, with two court reporters, the court's reporter and then our private reporter, and discuss this issue very as diplomatically as possible, but as upfront as possible. And to his credit, the judge, even though denied that he would put any thumb on the scale, we stopped hearing any comments or rulings based on cultural differences. And shortly thereafter, we got a very favorable settlement in the case. So that was a good outcome, born of some frustration in the court. Another outcome that was frustrating and did not come to a good outcome. We represented a judgment debtor. Okay, and there was an appeal. I was not appellate counsel, but I was kind of playing the gap role. So I was in between. I was the attorney helping with obtaining the bond and getting a stay of judgment enforcement pending the appeal. When the appeal was not successful, I had read the Supreme Court decision. The name is escaping me now. McQueen, maybe, that pointed out that if you pay a judgment, if you satisfy it in full, then that cuts off the right to getting any attorney's fees for judgment enforcement. So I thought, well, we've gone through a lot of judgment enforcement efforts, so there's going to be a big fee motion coming for judgment enforcement. Why not just cut off that right, show up with, but the exception is if you try to give a cashier's check or any other form of payment other than cash, then the judgment creditor can simply hold on to it and not cash it, proceed to file the motion for fees and say, no, I haven't, the judgment's not been satisfied in full because the check hasn't cleared. So the only way to actually take advantage of that Supreme Court rule, and the Supreme Court actually contemplated this, is to pay in cash. So we showed up, we had an armored truck show up at the attorney's office with the cash. It was about $250,000, as I recall, and pay off judgment interest in full. So there's no dispute it was paid off in full. They still filed their motion for fees, and we thought, we got him. We'll cite the Supreme Court case that says that, that's paid off in full. The right to attorney's fees for judgment enforcement is cut off. But the trial judge simply said, I don't like that result. I'm going to allow the fees anyway. And at that point, there was no gas left in the tank to take up another appeal. And so there is where it was left. We followed the Supreme Court's guidelines for how to do this, and yet judges sometimes just don't like the result. And so it's kind of a what are you going to do about it type of mentality that I find so frustrating.